recording. So welcome everybody to the residential lease or month-to-month rental agreement. It's always nice to have Peter Cam in attendance. If he needs to jump in and correct something I said or elaborate further, he's going to stop and jump in with me so that you get a full training session. And so let's take it away. This form was revised, as you can see here, December 2021, and there's some nice changes to it, and it's pretty comprehensive. So let's get going through this. It's a very important document. Leasing has almost the same amount of disclosures, maybe a little less, but pretty near same as if you're selling a property. We went over those disclosures last week, and there is a list of the required disclosures on our website. We also have our TC, Anna Flores, joining us in this meeting, so that's very nice. So welcome everybody, and let's take it away. If you need to mute yourself to talk, please do so. Okay, so we'll start at the top. The date that you type the agreement goes in here, your landlord name here, and the tenant name. Now, if you're the listing agent on this property that is up for lease, it is normally your responsibility, whether you represent the tenant or not, to type this agreement up for the landlord. And if you are the tenant's agent, it's good that you understand what you're reading on this form. So the property, the landlord is agreeing to rent. You put the address here. And B is very important. The premises are for the sole use and personal residence of the following named persons only. So if it's two names, I put them here. And then if they have minor children, I don't name the children because I don't feel like that we should do that, but I will put and two minor children or one minor child, whatever the case may be. So I'll name the adults here and one minor or whatever the case may be. Okay, so I do not name the child. I just state that there's minor children that are using this property as well. Okay, so the following personal property that will be maintained pursuant to paragraph 11. This could be a refrigerator, stove, microwave, things of that nature. Now, it would be pretty rare on a single unit that's not furnished that you would be attaching a personal property addendum. But if you lease this thing fully furnished, this unit, you would be checking that because you'd have a lot more to outline. So normally here, what I've seen, it's going to be a stove, refrigerator, things like that that are included. So the term begins, the commencement date goes here. So here you're going to check A or B. So some landlords don't want to do a lease. They want it a month-to-month lease. So it's going to be A or B that you're going to check. Make sure you check one of those. And if it is a year lease or 2-year lease, make sure that you're putting in the termination date and the time. I usually give them until 6 or 8 p.m. on the night of termination. So make sure that's filled in for the lease agreement. On month-to-month, obviously, you don't need to have a termination date because it is a month-to-month agreement. So the rent amount the tenant agrees to pay is here. Okay, so you can put the rental amount there. And it already defaults this contract that the rent is payable on the first day of each calendar month and is delinquent on the next day. Okay, so here it's saying when you move in, maybe you've requested a full month to be paid. I'm not talking security deposit, but you wanted a full month rent. If they moved in on the 5th, let's say the next calendar month, you would prorate and give them back their 5 days. So they would only owe you if it was a 30-day month, because everything's calculated off of 30 days. They would owe 25 days. So just keep that in mind. You can get the full month rent up front, but if they don't move in until the 10th or the 15th or somewhere in the month, the next month you need to make sure that they have the prorated amount that would be due. Okay, because not every lease will start right on the 1st. So the rent, this is important here. How does the landlord want to be paid? I know that some are requiring wire transfers. So anyway, whichever way the landlord wants to be paid, go ahead and check that box. And always make sure that it's made payable to. Put the landlord's name in, even though it's up top, put the landlord's name in here where you want the rent, the name of the landlord there for the rent payment. And rent shall be delivered to. Go ahead and rename them again. I think we shouldn't leave blanks as much as possible. Fill everything in, put their phone number, put their address. And if they have an office, you can put the hours that their office would be open. Maybe it's a property management office and they're open certain days a week. You could even insert that. So if the payment for rent is returned for non-sufficient funds, the landlord may require tenant to pay rent in cash for 3 months, or all future rent can be required to be paid either money order or cashier's check. So make sure that you are checking one of these boxes ahead of time on the unfortunate event that something happens like that. So make sure that agents, you're filling this out. The security deposit, you insert it here. We'll go over the limits, the legal limits. It'll state it down in the base of this agreement further down. So the tenant agrees to pay, insert your security deposit here. And it said it has a box here for held in owner's broker trust account. I always check transferred and to be held by here, this one, by the owner. So we always want to check that we're transferring it to the owner. Okay. And the cashier's check would be handed directly to the landlord. We don't hold it. It's not made out to Coldwell Banker George. It's made directly out to the landlord. So here, if a tenant defaults on a rental payment or doesn't pay you your late charges as a landlord, you can deduct it from the security deposit and take that late fee from them. However, the security deposit cannot be used by the tenant for the last month's rent. So some tenants think they can use that security deposit for their last month's rent. No, they can't. You still need to do a walkthrough and check that unit to make sure everything's fine. So the landlord has within 21 days after the tenant vacates the premises to furnish the tenant with an itemized statement indicating the amount of the security deposit received and the basis for its disposition and supporting documentation, and return any remaining portion of the security deposit to the tenant. So if the landlord needed to deduct for items such as abnormal wear and tear or damage to the unit, they should hold on to those receipts and make a statement to the tenant and provide them the receipt so they know why their security deposit was deducted from. So C is bolded, saying that the security deposit will not be returned until all tenants have vacated the premises and returned all keys. And also, the security deposit is made out to the tenants named on this agreement. So there may be 1, 2, or 3. It's going to be made out to the tenants on one check. Okay, so who's ever on this agreement, that's what the check will state. No interest will be paid on the security deposit unless it's required by local law. So I like this right here. It says if the security deposit is held by the owner, which in our case for Coldwell Banker George Realty, it would always be, the tenant agrees not to hold the broker responsible for its return. Okay, so that's very important for us and a nice protection. So moving on to your move-in costs here. So move-in costs shall be paid here for us. I always check cashier's check. The first time in, I want a cashier's check because it is cash. So don't forget to check one of these boxes. I recommend for the first month in security deposit, you're getting a cashier's check made payable to the landlord. So you indicate here what rent they're paying. That's probably going to be the first month's rent. The security deposit goes here. If you have a key deposit or anything like that, you can insert it here. It'll total down for you. Also, Here, make sure you're putting it payable to. It's always good not to leave blanks, even though we have the landlord on this agreement. Make sure you're putting payable to in these boxes and the due date. So right underneath this box, it's going to outline the maximum security amount of security deposit, however designated, cannot exceed 2 months rent for an unfurnished premises or 3 months for furnished premises. So here, the security deposit, let's say the landlord said, hey, I want, $100 each for my remotes. I would back out, if I'm doing 2 months, I would back out $200 from the 2 months rent that I'm allowed by law to charge, put $200 here. This would be less the $200 so that it equals exactly the 2 months, okay? So, and again, please make sure you're checking something up here. It's best to get cash for the landlord at the move-in date or prior to the move-in date. And also, if you're the one receiving the payment as the agent for the landlord, I will handwrite in a date that I received it, and I'll initial it so that the tenant feels good and they have a receipt that they've handed it over. I will also come back to the office and scan a copy of their cashier's check back to them, okay? So you just want to make them feel as comfortable as possible. So this one I was asking Peter about, because late charge amounts, I've seen different amounts. I know that normally we've been using about 5%. I think there's no set amount, but it must be reasonable estimated costs that the landlord may incur for the tenant being late. So here, right here, if they're late 5 days, or you can specify later, tenant shall pay landlord an additional sum of, you can either put a dollar amount or a percent of what you're going to owe for that late fee amount. And then NSF for the return check, if they have an NSF bounce check, it's going to be $35, 25 for the first one and 35 for each additional. Peter, do you have any comments on the percent for the late charge?
Yeah, well, the late charge has to be reasonable. Usually it's from 6 to 10%, no more than 10%, but you can just 5%, 6%, or up to 10%. So you just it's reasonableness. It's that it is not legally require what the late charges is, but again, it's the key is reasonable. But I think 10%, within 10% is reasonable.
Okay, so anywhere from up to 10% agents, and then you would put the percentage here. That should be a pretty good deterrent for people not to be late. And it says right here that the landlord and tenant agree that these charges represent a fair and reasonable estimate. Okay, so coming down to parking, this is important because you want to make sure that they understand where their parking is if there's not an attached garage. So you're either going to check A or B. So let's go to B first. Parking is not permitted on the real property. B, where could this happen? Maybe some beach areas. There's not an attached garage, the lots are pretty small. Maybe there's not on-site parking. So make sure if that's the case, you're checking B. So here, up here, parking is permitted as follows. If there's an attached garage, I will even put a garage attached to unit, or, if there's a parking spot on the premises that has a number, you're going to put parking space number, 1 parking space number or 2, whatever the case may be. Make sure you're pretty explicit about where they're going to be parking. The right to parking generally is included, but if it's not, check is not. And if there's an additional charge for parking, put it here. Normally around our area, I haven't seen that, but again, that could occur down in some beach areas where it's very tight. So make sure you're not leaving this blank. Even if it's abundantly clear to you where they would park, it might not be clear to somebody else. So just fill it in, put the parking space number, if it's 1 or 2 spaces, or if it's an attached garage to the unit, okay? So storage, again, check A or B. So let's go down to B first, because I think that this would be most of the check marks we would do, except for the tenant's personal property contained within the premises. Storage is not permitted on the premises. So you would check B. That means put all your stuff in your own, rental unit. So if you check A, storage is permitted as follows, you would fill in exactly what it is, and the right to separate storage space is or is not included. So if they have a space that they're going to allow the tenants to use, that's maybe some kind of space in the parking garage, I don't know, but you want to be very explicit and fill this in. Normally, you're going to be checking number B, that they contain all their property entirely within their premises. Okay, so those are very important. Don't leave blanks. Utilities, the tenant agrees to pay for all the utilities and services and the following charges. Now, what would be following charges? Here, I would put Wi-Fi and telephone, anything that the landlord will not be paying for. You put here, like if they're not going to pay for the Wi-Fi, make sure you're making that clear to the tenant and the tenant's agent. So put Wi-Fi, telephone service, anything like that, that the landlord will not be paying. So except maybe the landlord here will be paying the HOA fee if this property resides in an HOA. So you could put except HOA fees, or if there's no exception, just put NA there, okay? Now here it's telling you if any utilities are not separately metered, the tenant will need to pay their proportional share as determined by the landlord, reasonably determined. So if the utilities are separately metered, the tenant needs to place those utilities in their name as of the commencement date. So agents for landlords, make sure, because unfortunately I had this happen where they said they turned on the utilities in their name, but they didn't. So make sure that the landlord calls in and does what we call a soft close, give a close date to the utility companies, and then that tenant can call in behind and just switch it into their name. So you want to make sure to protect your landlord. If the tenant is indeed paying for those utilities, make sure you advise them to call the utility companies and place a date that those utilities will go out of their name, and advise the other agents to go ahead and have their client call in to switch those into their name as of the commencement date. So that'll save some grief in case people, don't switch like they're supposed to. So if there's a water submeter, we went over this last week, make sure that you're attaching the car form WSM. You'll need to ask the landlord, do you have a submeter for that property, or are they separately metered? A lot of your larger condominium projects are probably going to have submeters, okay? So any of these that pertain, make sure you're checking the box. If none of them pertain, you can leave those blank. Condition of the premises, this is very important. Tenant has examined the premises, and if any, all the furniture, furnishings, drapery, whatever, and including smoke alarm and carbon monoxide detectors. As your listing agents, make sure that the landlord has those already installed and understands if they're not there, that they need to get those in prior to commencement date. So you have several boxes here to check all that applies. So I think I would check, if it's me, I'm going to check B. So this is the move-in, move-out form. It is a required document here at Coldwell Banker George Realty. We need to have that done. So you can provide this form to the tenant, check this box. You can let them into the unit prior to commencement date. Let them walk through the unit and note the condition of the items and have them sign it. It has two sides of the form. One will be for the move-in side and the other is for the move-out date. The landlord will also be signing this document. So make sure that you are documenting that not you, but the tenant is documenting the condition of the unit on an MIMO. And then that's all I would check there. If you want, you can say that the tenant will provide. You could also check this if it makes you the landlord more comfortable. A list of items that are damaged or not operable condition within 3 days. But I think it's sufficient to check the move in, move out, to provide the move in, move out document. have the landlord sign it and return it as soon as possible by commencement date to the tenant. Okay, so maintenance and use. So here the tenant shall properly use and operate and safeguard the premises, including, landscaping, furniture, furnishings, things of that nature. And it also even says the tenant shall replace any burned out or malfunctioning light bulbs. That would be very frustrating for a property manager to keep getting requests to replace light bulbs. And I know in the past that has happened. So please make sure that the light bulbs are working when you move it, when the landlord moves a tenant in. Thereafter, the tenant needs to replace those burned out light bulbs. Okay, so this is very important here. So is it the landlord or the tenant? Probably this would pertain more to a single family home, but make sure you're checking a box. If it's an HOA, you don't have to worry so much about the water, the garden, landscaping, and trees if the property is residing in an HOA. If it is a single family, that becomes very important. The landlord may maintain it with their own gardener. It's probably good to do that so your property stays looking fresh. Okay, so here they have two boxes here you can check and with any exceptions. But here, landlord and tenant shall maintain. So what could go here? So in one property we were leasing, we put patio connected to unit and plants on patio. Reason why we did that is because these were locked patios. Even though they were ground floor, the gardeners can't get in. They cannot get into those patios. They're not going to jump the fence. So if you have something where it's a ground floor patio, even an upper floor, just make sure that the tenant knows they need to maintain those, keep them clean, free of debris, stuff like that. Okay, so you could place something like that there. And then the landlord and tenant, because we have so many water rules now, agree to abide by the local water use restrictions. Tenant's failure to maintain any item that the tenant is responsible for gives the landlord the right to hire someone to perform that maintenance and to charge the tenant to cover the cost of the maintenance. So these boxes up above become very important, that you check whatever fits that particular unit. The following items of personal property are included in the premises without warranty, and landlord will not maintain, repair, or replace them. So this could be your refrigerator, stove, anything like that. You want to make sure you insert in there, because you don't want tenants clogging up the stove because there are sloppy cookers or something like that, or they're just, things are dripping into the burners. You want them to maintain that, because you turn them over in good working condition, you expect them to maintain that good working condition. And here it's telling the tenant that if the premises is located in a common interest development, the landlord may not have the authority or control over certain parts of the premises, such as the roof, electrical, gas, or plumbing features inside certain walls and common areas, such as shared parking structures. Here, a tenant shall not use the premises to plant, grow, or cultivate or sell marijuana, which should be, that's really a good protection for, for our landlords. They've added some really nice stuff to this contract. So the neighborhood conditions, the tenant is being advised in paragraph 12 to go ahead and check the neighborhood himself or herself for the conditions, including the proximity to schools, law enforcement, crime stats. That is for the tenant to go check. Okay, so this is a really nice paragraph. The tenant can go ahead and check the neighborhood and all the surrounding areas prior to leasing. Pets, unless otherwise provided for in Civil Code 54.2 or other law, which would pertain to emotional support animals, things of that nature. Those are, you always have to allow those. Or accept as agreed. If the unit is allowing a pet, make sure, agents, that you attach the pet addendum so that the landlord has in writing what animal that is, and that everybody's signing for it, and that that's the only animal or animals there. Okay, so this clause is very good because it's saying basically that the tenant is responsible if they cause damage by smoking, stains, burns, odors, and things of that nature, and removal of debris. I've seen property where people are throwing cigarette butts all over the place. So this is a really good paragraph. And it's also saying no smoking is allowed on the premises or common areas. Okay. And if the tenant smokes and does not listen to this paragraph, they're in material breach of the agreement. Or if you check this box, which I have not seen done, usually that remains unchecked. Smoking of the following substances only is allowed. Leave it unchecked for most cases. Most landlords don't want smoking on or about their property. Rules and regulations. So the tenant does agree to comply with the rules and regulations provided by the landlord. So if applicable, this says if applicable, check 1. The landlord provides the tenant with a copy of the rules and regulations, check, or the tenant has been provided. Okay, so the landlord may have some of their own rules that they've typed up or have a sheet on. So if that's the case, you probably want to provide it up front to the tenant. Now, if it's a condominium or planned unit development, generally the HOA has their own rules. Please insert the name of the HOA here. Get that. If you don't know it, ask the landlord for it. And here you want to check 1. The landlord shall provide the tenant with a copy of the HOA rules within X amount of days, or put a date. But I like it better if you provide it with the lease agreement. So if there's anything in there that they don't like, they've had a chance to pre-read it. So please make sure you're checking one of these boxes if it is indeed a condominium or planned unit development. So that protects everybody, and that the tenant understands the rules of the complex. Okay, so alterations and repairs. One thing to remember on this is just that if the tenant is making any alterations or repairs to the unit, that they need to get the landlord's prior written consent, excuse me. And the landlord is not responsible for the costs of alterations or repairs made by the tenant. Okay, so if the tenant wants to paint a whole room pink or something, they need to have landlord's prior written consent. Okay, so we're moving on down to keys and locks. The tenant acknowledges receipt, or the tenant will receive. You can check prior to commencement date, or here I usually insert the date of commencement date, get them out early in the morning to them. That's up to the landlord. Okay, so it is important to check these and say how many keys you gave to both. To all things, there may be 2 remote controls, or there may be a key to the, 2 keys here, 1 mailbox key. Make sure you're inserting this and a key, how many keys you gave to the common areas, because sometimes these keys can cost, especially for common area keys, up to $100. So make sure you're filling that in and providing those keys on the commencement date, or if you're going to do it prior to, check that box. Now, here's a very, very important paragraph for you to check. Tenant acknowledges that the locks to the premises, folks, make sure you don't leave this blank, have or have not been rekeyed. Very important on B. Make sure you're checking one of those. Now, if it's a have not and the tenant wishes to rekey the existing locks or opening devices, the tenant needs to immediately deliver copies of all the keys to the landlord. Tenant shall pay all costs and charges related to any loss of any keys or opening devices. And tenant may not remove locks even after they installed them. Okay, so very important, check whether the premise locks have have or have not been rekeyed. If they have not been rekeyed, it's okay. Just make sure you're checking it so the tenant is well advised. Okay, entry. The tenant shall make the premise available to the landlord or the landlord's representative for purpose of entering or making necessary or agreed to repairs. Okay, so usually the landlord and tenant agree a 24-hour written notice is reasonable and sufficient notice, except as follows. 48 hours written notice is required to conduct an inspection of the premises prior to the tenant moving out, unless the tenant waives this right. So the landlord would most likely go in with the move in, move out form, go over that form with the tenant. The tenant and landlord would be looking at all the questions on that form and document anything that is unsatisfactory or that the landlord needs to bring to their attention. Okay, and here's an important one. If the landlord has in writing informed the tenant that the premises are for sale and that the tenant will be notified orally to show the premises, okay, for the next 120 days, the following delivery of the NSC notice will be given orally to show the property to actual or prospective purchasers. So if a landlord puts a building up for sale, they will need to provide the tenant with car form NSC. I will show you at the end what that is. And then that gives the right to the landlord or the representatives to orally notice the tenants that they will be showing the property for the next 120 days to any prospective purchasers. So no written notice is required if the landlord and a tenant orally agree to an entry for agreed services or repairs if the date and time of entry are within 1 week of oral agreement. Okay, so I'm going to show you that form at the end so that it's not confusing. So I've already pulled it up. It's called an NSC. So we'll go over that at the end. And here, if you check, that means the tenant authorizes the use of a key safe lockbox to allow entry into the premises. So for me, it's really up to the landlord. If they ask my opinion, I probably would not want a lockbox on the premises with tenants in it, just so it makes everybody comfortable. But again, that is a landlord's call, not ours. So if the landlord wants to do that and have the tenant authorize the key safe, if the tenant does, then you need to submit car form KLA with this agreement. So photographs and internet advertising, we get a lot of calls where, hey, can you pull my property off the internet? So once the photographs are taken, the broker cannot monitor. We have no control over who can see the images, where they're posted online. So this paragraph is explaining that. So if we take images, everybody needs to know we don't control all those other websites who pull directly from MLS and place them. Okay, so the tenant also acknowledges that prospective interested persons coming into the premises may take photos or anything like that of the premises. We do not have the ability to control or block the taking or use of images by such persons. So when they're put out on electronic display on the internet or otherwise, the broker or the landlord, we can't control that. You'll see them sitting sometimes on websites online for, I don't know, 3 to 6 months later. Okay, so that's an important paragraph that explains that to the tenant. Tenant authorizes the landlord to place for sale or lease signs on the premises. So they already have given, via signing this document, the authority for the landlord, if need be, to place a for sale or for lease sign on the premises. Assignment or subletting, it's not allowed unless it's agreed to by the landlord. And this prohibition also applies to short-term vacation and transient rentals. So unless you check this box, it applies to all of that. So it's probably recommended not to check the box unless the landlord tells you something different. Joint and individual obligations. Sometimes you'll have students, there'll be, 3 or 4 of them in one unit. So if there is more than one tenant, each one shall be individually and completely responsible for the performance of all obligations of tenant under this agreement jointly with every other tenant and individually, whether or not in possession. So we do have, young people renting together. So that covers that they're responsible in full for that lease if they sign this document. Peter, are you here? Peter?
Yes.
Okay,
Yes, I'm
so if we have four young students that rent and one's not paying rent, the
Yeah,
other
then
3 need to make it up, correct?
Yes, that's good. Definitely.
Okay.
It's jointly and severally responsible.
Okay. So that's nice for the landlord because we have had those situations where one young person or isn't paying and the other 3 had to. So that you can point out if you're renting to tenants to the landlord, okay? That or there's more than one and it's not a family. So possession, tenant is in possession of the premises. If landlord, this is important, if the landlord is unable to deliver possession of the premises on the commencement date, such date shall be extended to the date on which possession is made available to tenant. Here's the default on this. If landlord is unable to deliver possession within 5, or you can insert the calendar days after agreed commencement date, the tenant has the right to terminate this agreement by giving written notice to the landlord and shall be refunded the rent and security deposit they paid. So maybe there was something that needed to be repaired and the tenant didn't want to move in till it was done. That's the only thing I can think of why the possession, wouldn't be delivered to the unit wouldn't be delivered to the tenant in time. But that's a nice protection for the tenant. Or B, tenant is already in possession of the tenant. That's normally not checked, but if that's the case, go ahead and check it. So tenant's obligation upon vacating the premises, they need to give the landlord copies of all their keys and opening devices, common area, keys, things of that nature. They need to vacate and surrender the premises to the landlord. Make sure everybody's out, personal belongings all removed, and vacate any parking and or storage space. Clean and deliver the premises to the landlord in the same condition as it was delivered to the tenant. Make sure you're not leaving debris on the patios. Give the written notice to the landlord of tenant's forwarding address. So when the tenant is giving notice, make sure that they are supplying the landlord with the forwarding address. This will help with returning deposits and things of that nature. If there's any additional items that the landlord would like to note here upon vacating the unit, they can certainly note it. Any altercations or improvements made or caused by the tenant with or without the landlord's consent become the property of the landlord upon termination. So if they installed something on the wall, like like a bathroom cabinet, that needs to stay at the property, okay? Or the landlord may charge the tenant for restoration of the premises to the condition it was delivered to them prior to any alterations or improvement. Again, this goes back to the tenant getting permission from the landlord to make any alterations and improvements. So it's best for them to do that. So the tenant has a right to a pre-move out inspection if they wish. So after giving or receiving notice of termination of a tenancy on or before the expiration of this agreement, the tenant can request that an inspection of the premises take place prior to termination. So if the tenant requests that the landlord provide such an inspection or the property management, the tenant is given an opportunity to remedy any identified deficiencies prior to the termination. So if the tenant wants to go over the unit with the landlord or its representative, they can go ahead and ask for that ahead of time. Okay, so breach of contract, early termination. In the event termination by tenant prior to completion of this original term agreement, the tenant is also responsible for any lost rent, rental commissions, advertising expenses, etc. So the landlord can also withhold any such amounts if they have enough from the tenant's security deposit. So temporary relocation. So what would this be for? Maybe like they're saying it could be fumigation. So subject to local law. This is for the landlord to know the local law. We don't have to advise on that, but here is a paragraph on it. Tenant agrees upon the demand of the landlord to temporarily vacate the premises for a reasonable period to allow for fumigation or other methods to control wood destroying pests or organisms and other repairs that the landlord may need to make to the premises. And the tenant agrees to comply with the instructions and requirements when the termite company asks you to bag or store food or medicine or perishables, they need to comply with that. So that paragraph covers that. Damage to the premises, if by no fault of the tenant, the premises is totally or partially damaged or destroyed by fire, earthquake, accident, or other casualty that render the premises totally or partially inhabitable, either the landlord or the tenant may terminate this agreement by giving the other written notice, and then the rent shall be abated as of the date that the premises became totally or partially uninhabitable. Okay, so insurance, very important here. So this is outlining that the tenants, guests, invitees, are licensees' personal property and vehicles are not insured by the landlord, manager, or if applicable, HOA against loss or damage. So it's even advising them to carry their own insurance, renter's insurance. So here the tenant shall comply with any requirement imposed on tenant by landlord's insurer to avoid an increase in the landlord's insurance premium, or the tenant shall pay for the increase in the premium that they caused or loss of insurance. Here you can check the tenant shall obtain liability insurance in the amount not less to. Ask the landlord if they would like the tenant to obtain their renter's insurance and provide them a certificate by commencement date. A lot of landlords want this now, and then the landlord will tell you an amount not less than, and it also specifies that they name the landlord or, if applicable, property manager as an additional insured. So very important on insurance. Things can happen, people can get hurt. It's good if the landlord wants to require a certificate of liability insurance from the tenant. You check this box, ask them an amount not less what the landlord prefers. Okay, so water beds and portable washers. Tenant, this paragraph is kind of important because I've seen those portable washing machines that when my daughter is in college, they do make a mess with water. So for me, I would probably check both of these boxes for the landlord so that the tenant shall not use these on the premises, because we don't want water and then maybe somebody doesn't clean it up. But for me, on behalf of the landlord, I will explain it to him, and I will normally check these boxes so that there's no water on the floor. So these are very important notices here. Notices may be served at the following address or any location subsequently designated. So folks, make sure you're filling in the landlord's name, delivery address here, and make sure you're also doing the same for the tenant so that if there's any communication that they won't miss that. So make sure these delivery addresses are accurate. Okay, tenant estoppel certificate. So tenant shall execute and return a tenant estoppel certificate delivered to the tenant by the landlord or landlord's agent within 3 days after its receipt. Failure to comply with this requirement shall be deemed the tenant's acknowledgement that the tenant estoppel that the landlord provided them is true and correct and may be relied upon by a lender or a purchaser. So I've seen cases where sometimes a tenant does not want to sign that estoppel. So right here, you have some protection right in this agreement. that if they don't want to sign it, then that's deemed reliable, okay? A reliable representation. So representation, tenant representation obligations regarding occupants. So the credit, tenant warrants that all statements, very important to get a rental application, are accurate. That applies to any occupant that is 18 years of age or older, and all emancipated minors. So they all need to complete separately a lease rental agreement. And that is required. And normally you're going to get a copy of a government issued ID. It can be a picture of their current driver's license or passport, anything like that. Okay, so make sure that when you are assisting a landlord that you do collect a full package for them so they can make a good decision on the tenant. Make sure you have with that package all applications, copy of a government issued ID, talk to the landlord about it, but normally if they're self-employed, 2 years of tax returns. If they are employed, you're going to want the last 2 to 3 months of the most current check stubs, and that goes for every applicant, okay? So, and you talk to the landlord about that and make sure that that's the type of package they want to see. So the landlord represents that they're not aware of any recorded notices of default affecting the premises and any delinquent amounts due under any loan secured by the premises and any bankruptcy proceedings. So the landlord makes those representations to the tenant. Mediation. Landlord and tenant agree to mediate any dispute or claim arising out of this agreement or any resulting transaction before resorting to court action. Okay, so that's stating that before going to court that both parties have agreed to mediation. So there are some exclusions from mediation. It's an unlawful detainer action, the filing or enforcement of a mechanic's lien, any matter within the jurisdiction of a probate, small claims, or bankruptcy court. Okay. So the landlord and the tenant do agree to mediate disputes or claims also involving a listing agent, leasing agent, or property manager, provided the broker shall have agreed to such mediation prior to or within a reasonable time after the dispute is presented to such broker. So that request would go to our broker, Peter Cam. That won't happen. I haven't seen it, so we're all pretty careful. Peter, do you have any comment on that?
That's okay.
Yeah, okay.
Yeah. Mm-hmm.
Okay, so this one, Peter may have a suggestion. So the attorney fees, this is embedded right into the agreement, as you can see. If in any action or proceeding arising out of this agreement, the prevailing party between landlord and tenant shall be entitled to a reasonable attorney fees and costs collectively not to exceed 1,000, except as provided in 35A. I usually put 2,000 in here because I'm not sure 1,000 would cover that. What do you think, Peter?
Oh, no, 1,000 is definitely not enough.
It's not enough, right?
Yeah.
So what do you suggest? I'm normally putting 2,000 in.
Yeah, or you said as needed, as for the attorney fees. If you don't want to put any amount, you can say just as needed.
Oh, okay, good idea.
Yeah,
okay.
Because the attorney fee is very difficult to
predict.
Yeah, especially when you're trying to collect and UD and all that, bundle in.
Yeah.
So you don't want to restrict yourself to $1,000. That's
right.
Usually not enough.
So agents, let me see, I don't think it'll, okay, so you type in here as needed, because $1,000 would not be enough, okay? So make sure that you are covering this attorney fee box, because if you restrict them to 1,000, it's 1,000, okay?
Yeah.
Okay, so statutory disclosures. This mold and dampness is automatically checked. We went over that disclosure last week, and the book entitled Information on Dampness and Mold for Renters in California, that will already be attached to this agreement. So this is a pre-checked box, so you don't have to worry about it. And the booklet will be pre-attached. Lead-based paint only is applicable for units that were constructed prior to 1978. So if that's the case, it was constructed prior to, you would attach that. So periodic pest control, check if either applies. I'm going to start on 2 first. So if the premises is a house, maybe the landlord wants the tenant to be responsible for some periodic pest control, so they would check here. That's up to the landlord. Or maybe the landlord has a contract with a company for periodic pest control treatment. So if either of these apply, please make sure you're checking that box. Methamine contamination, I know I'm not saying that word right, but I've never really seen this box checked, but if that's the case, go ahead and check it. That is for the landlord to let you know. Bed bug disclosure is already going to be part of your disclosure package. Megan's Law database, like we said when we were going over the contract for selling properties, this is for the tenant to check. Please do not check this website for them. We don't know if it's always updated or anything. We don't want to be responsible for providing that check for a tenant. So Megan Law database, they're giving them the website to go check it themselves. Agents, let them do that themselves. That's not our requirement of agent to do that for them. So it even says here, if the tenant wants further information, tenant should obtain information directly from the website. So let them do that. Residential environmental hazards booklet. I usually check it and I put a copy of it in the kitchen. It is a big booklet. If you check it, then the car forms will populate with the booklet. You can either send it electronically or I just print it and leave it in the unit. And I have the tenant sign the first page that they received the booklet, but that's up to the landlord and up to you as their agent, whether you want to check that or not. Military ordinance disclosure, if it's known to the landlord, whether or not it resides within 1 mile, check that or not. We went over the flood hazard disclosure, car form TFHD pretty extensively. That is required. The ESD, exempt seller disclosure statement, is a required statement, but also here it is asking again, was there a death on the premises? Did an occupant of the premises die within the last 3 years? If so, please check the box. If you have any other material facts to add, the landlord has any other material facts to add, please check this box, okay? And have them tell you what to add here. It's best to draft this agreement in advance, you know, of the commit. Well ahead of the commencement date if you can. Let the landlord have a draft and let them review it, or you go review it with them. Now, number 39, Service Members Civil Relief Act. This means if a service member, we probably wouldn't have much of this, maybe it's more San Diego, wherever bases are. If they get transferred somewhere out of the area, then they can break the agreement. I do have this civil Service Member Civil Relief Act in my documents here. If anybody wants a copy of that, if they're leasing in areas where there's a lot of service members, you know, give me an email and I'll send that over to you. So time is of the essence, and all understandings between the party are incorporated in this agreement. There is no verbal in real estate. So it's telling you that everything is in this agreement. Make sure that you have the confirmation of agency filled out properly. So here, if you're representing both, click both. Make sure you have the license numbers here. Okay. Okay, I'm just putting any number there. Okay. So if this lease is for more than a year, please check this box. Okay. But regardless if it's for more than a year, we as a brokerage, we still want you to provide an AD form. So if you check this box, it will automatically populate an AD form. However, we still would like you to have that agency disclosure form so that everybody's advised of that. So please provide the AD form, whether it exceeds a year or not. Okay, so that's a good protection for all of us. So I like this paragraph here, termination of agency relationship. So the landlord and the tenant acknowledge and agree that unless the broker, us agents, are the property manager, or as specified in 2 below, once the landlord and the tenant enter into this agreement, the broker does not represent the owner in any manner regarding the management of the premises and representation duties that the broker may owe to, and any agency relationship that broker may have with either the landlord or the tenant is terminated. So down here, you see notwithstanding 41C1, this paragraph, broker's duties and responsibility to the landlord and the tenant will terminate upon the last to occur of the following. Choose all that apply. Peter can correct me as wrong, but I would probably put tenant occupancy or delivering the keys. Which one do you prefer, Peter? I would say.
Can you repeat your question again?
Yeah, the broker, when we are going to terminate our responsibilities, our agency relationship, we can check a box. I would say upon tenant occupancy, we're terminating our agency relationship with the landlord and the tenant, correct?
Yes.
Okay.
And
So,
then, yeah, you can also put the delivering the tenants.
okay. So both of those
both of
boxes.
them should be checked.
Okay. So this is agents, this is new, and it's a really great protection for us, because that means our agency relationship is terminated upon these 2 activities. Make sure that you're not leaving that blank. Please check them. Our TC will be looking for those check marks. So please make sure that we're checking these for the agency. Tenant compensation to broker. Normally it's the landlord paying, but if it's the other way around, go ahead and check that. Okay. If it's a foreigner and they've had foreign language translation of the lease agreements, the civil code requires a landlord or property management to provide a tenant with a foreign language translation copy of the lease or rental agreement. I haven't seen this too often, but that's just a paragraph advising you of that. Owner compensation to the broker. Upon execution of this agreement, the owner does agree to pay compensation to the broker as specified in a separate written agreement between the owner and the broker. And that's usually on your listing agreement. Okay, so make sure you have your percent in there. So other terms and conditions, it automatically checks in this form. These are pre-checked: bed bug, rent cap, and tenant flood. We went over those last week. Representation capacity, if it's an entity signing this, please make sure that you are attaching that representation capacity form. And this is a nice box here that the landlord and the tenant acknowledge and agree that the brokers do not guarantee the condition of the premises and cannot verify representations made by others, etc. This is a very nice protection box for all of us. If there was an interpreter, you need to check this box and indicate a language. The premises is being managed by the owner. You usually leave it there. Real estate broker, property manager. If you've checked this box, you're going to need to fill all this out. But I usually would leave it to the owner unless the owner directs you differently. So we're at the bottom now. The tenant agrees to pay, agrees to the above terms and conditions. So go ahead and have them sign here. If there's more than 2, you can attach an addendum so that they can sign, more tenants can sign, and it's on car form ASA. Okay, if they're going to be filling out a representation capacity, also make sure that you check that box. If there's a guarantor, guarantee, make sure you're checking this box, print their name, address, and all of the information here. If you do have a guarantor on this lease, make sure that you've done the same package for the landlord, collecting their application, because if the tenants default, it will fall to the guarantor. So make sure you're also providing a package for that guarantor. The landlord will sign down here, put in their address and telephone number. And here, it's just like on the offers, we're gonna go ahead and fill this out in its entirety. So that concludes the lease agreement. It's very lengthy. They've added some really nice stuff. We went over it fast. So go ahead and please review it. If you have any questions, then let us know. Okay, and then I'm going to be looking. Okay, so I'm going to be looking in the question box. Okay, so I'll let Peter, Rosa's asking,
Yeah.
how does this form differ from property management?
Which form?
This form
Yeah.
is a lease agreement, Rosa. And
Okay.
yeah, it's a lease agreement. We're not, how does it differ from property management? Once this form is completed and delivered, we don't have any further agency. We check the box. We are merely helping the landlord to get this lease agreement completed. Property management is a whole different animal. It's collecting rent, you know,
Okay.
things like that.
And how would we charge the landlord?
Okay, it's on your listing agreement. So there's, excuse me, there's a lease listing agreement. And embedded in that agreement, like any listing agreement, is going to be the percent that you charge. And
Okay.
it will be based on if you have 12 months, if you're charging for 12 months, then it'll be, you know, $3,000 times 12 times 5% or whatever the percentage is that you're charging the landlord.
Okay.
Yeah.
That's correct. That's correct.
Okay, and Christine Finn wants to know, after the tenant replaced a stove or appliance, who does that appliance belong to? That's interesting. I think talk to the landlord before you replace it and make sure that, oh, I'm sorry, my screen went crazy. I think, Peter, they would talk to the landlord that they want to keep it as their own personal property if the stove or refrigerator needed replacing.
Yeah, they can do that. It's really a negotiation between the landlord and the tenants. So there's no fixed rules.
Okay, and then Kirshna is asking, how much do you charge for a lease contract, customary range? You know, try,
Usually 6%.
yeah,
So it's just like you know, your regular sales, purchase and sale commissions.
mhm,
Unless it's a very large
Yeah.
lead, you know, then you may lower it to 5%, but usually 6%.
okay, and then Anna, you're asking, let me look and see, 41A is not complete. 41A. Yeah, if they don't complete the confirmation of agency, Anna, and agents, it is the same thing. They need to complete 41A, that's the confirmation of agency. If you don't, then you need to do the additional agency confirmation form. So please make sure on both sides, if you are the listing agent or the tenant's agent, make sure that 41A is completed properly. If not, you're going to need to do an extra form. Yes, yes. Thank
May
you,
I
Anna.
say something, Michelle?
Yes.
Again, I find that for some reason, they write their information and the other side, they forget to write their information or they forget to check the boxes. And then suddenly what they want to do is go in there and just manually check things. Well, once it's been executed, signed by all
Correct.
parties, you can't go after the fact and change it. And I have to
No.
explain to them, I still need the AC. You failed to complete this correctly. We now need this additional document. So just wanted to clarify that.
Yeah, that's correct, because if it's not done when everybody's already executed it, or you received it not complete or wrong, go ahead. Like if I left this license number out and everybody signed it, or the tenant's agent, you know, said, hey, this isn't right, you know, before anybody signs, you would have time to correct it. But if people have signed this, you have to provide that AC form. So make sure this is all done properly. and you have the right license numbers is extremely important. And that you are, checking the right box. Now, what if this was down here, Kenny Fan? Okay, what if this was this agent from Coldwell Banker George Realty? Remember, we are still dual. If it's Michelle Olson Coldwell Banker and a Coldwell Banker Kenny Fan, we're still dual agents. Okay, so just something to remember on that. Is there any other questions? If you sign. Oh, okay. Kenny is asking if you sign the contract for 3 years, will you get paid 3 years?
Yes,
Okay. Yes.
definitely. You get whatever the term of the lease, you get paid for whatever you agree on the percentage.
And you can stipulate that, Kenny, on your listing agreement, your lease listing agreement, you can stipulate it. Okay, so that it's you're covered. Okay. So you can put, between 1 to 5 years, whatever, but you can stipulate that too. And the landlord would sign that listing agreement. So you
Can I make a comment? I'm sorry. There has been situations where the lease is for 3 years, but they only want to pay for 1 year. So you got to be very careful on the MLS of how it spells it out.
Right, and stipulate that in your lease listing agreement. If we are the
Yes.
listing agent, make sure you stipulate that. And if you are the tenant's agent, then you will be paid, as posted on the MLS. Unfortunately, that can happen, but for us, we can control our contracts. Or you ask the other agent to pay you for the full term, okay? Because sometimes they'll have first year rent, FYR, on the MLS, which means first year rental amount only. So if you see that, make sure you're already talking to the other agent if it's longer than a year, okay? Any other questions? So Kenny, yes, you can get paid 3 years.
Okay,
Peter?
if there's no other questions, I would like to have some comments on the security deposit.
Okay,
Now, the cap on the security deposit for 2 months for the unfurnished and the 3 months for the furnished, that's the statutory required. So don't go over the limit. Okay, it's statutory required for residential leases, but not for commercial. Commercial, you can do whatever you want. It's between the landlord and the tenant. But for residential, you're stuck with the limit. And also the security deposit cannot be used by the tenants to offset the rent, but the landlord can use the security deposit for the delinquent rent when they move out. Okay, so that's the difference. And also for the condo, if you have you're renting out a condo unit, you have to give the tenant the package for the HOA, including the CCNR. That's very important, because if you don't give them those documents, then they can say, oh well, I'm not obligated to the rules and regulations of CCNR. Then the landlord will be in trouble with the HOA. So make sure that you do that for give that disclosure to the tenants. Now for the assignment and the subletting, it's very important that you definitely don't want to give the tenants any right to sublease, because nowadays people after they lease the property, sometimes they lease it out to the people who are growing marijuana, and then you're in big trouble, because ultimately the landlord is going to be responsible for the damages and for the violation of the law. So you make sure that you don't let the tenant do the Airbnb, and also not to use the property for the marijuana growth. And okay, and also the mediation are not necessary, but and you don't have to agree to the mediation, but it's recommended because because it's the most economic way to settle the disputes. Okay, so that's all my comments.
Okay,
Questions?
if anybody else has a question or a comment, unmute yourself if you're not already and let us know.
I have this is Val. I have a,
Yeah.
is it advisable to take the last month rent or lease or not? What is better? Like take a last month or not? Just to take first month as security or just take first, last as security?
Well, the security, make sure that you don't violate the rules of security. The last month's rent is supposed to be for the security deposit. Okay, so if you can take the last month's rent and then you take 2 months security deposit, then you violate the rules.
Oh, that goes into, I see.
Yes.
That's the best than not to take the last month rent, just 2 months security. That's
Yeah,
it.
yeah, sure.
Okay.
Mhm.
Okay, thank you. Yeah.
You are welcome.
Anybody else?
Oh, yes, Peter, this is Clint.
Clint.
You're saying the maximum is two months of rent for the security, so that's okay, right? If I take 2 months rent for security.
For the unfurnished. But
Yeah,
for
2
the
months.
furnished, you cannot take up to 3 months.
Okay, so 2 months, and then you can also add on to other things, like for example, key and other stuff. Those security, when they add on over, it's going to be over 2 months. Would that be okay?
No.
Then Michelle just told you that those
Okay, has to
yeah,
be
for if
not
you're-
over 2 months. Okay,
yes.
gotcha. Thank you.
Mhm.
I have a question. Can we provide the service for out of state? The landlord resides in California, but the home is in Nevada.
I mean, can you lease the property? No, you cannot do
Okay.
any real estate activities outside the California. You have to have somebody in the other state to do it for you, and then you get the referral fees. That's okay.
Okay.
Mhm.
Any other questions? Okay, I think that, let me look in the chat box one more time. I think that concludes it.
Yeah, that's very thorough, Michelle. That's a very good session for the,
Great job, Michelle.
yeah.
very thorough.
good job.
Oh,
Very
wait,
good.
oh, you guys, I'll answer, if anybody needs to leave, you can leave, but let me see. Let's see, there's more messages coming in. How do you calculate a month to month? Okay, Jesus, okay, you're asking how do you calculate a month to month? I've done month to month leasing where it was all furnished. And that's up to the landlord. They may give you a higher, a structure like I think the one that I did, he was giving 12% because maybe somebody would only be staying for 3 months. So that would be 3 months times, like, let's say it's 12,000 for 3 months times. So, they might pay you or cap it off at 500 to 1,000. So that's up to the landlord. They can either cap it off or they can pay you a percentage of the months that the people are staying. And that comes in, Jesus, into your listing agreement. Okay. So if you need help on that, you talk to me. And which form from Kenny Fan, which form we need to fill out attached with the, okay, Kenny, there's a whole list of disclosures, and I will email you that list. It is also on our website, but I have it printed. I'm going to email you the disclosures that are required for a lease agreement. Does that answer your question, Kenny?
Okay.
Okay. Yes.
Very good.
Okay. Okay. Thanks, Kenny. I'll get that out to you.
All right. I think it's way over time, so I think we should conclude this session.
Okay. Thank you, everybody, for coming.
All
Thank
right.
you.
See you, everybody. Bye-bye.
Thank
Bye-bye.
you.
Thank you. Have a good weekend, y'all. Bye-bye.
Bye.
You too. Thank you.